Ladies and gentlemen, I would like to read to you the case summary of Eric Anderson's case. A man who has been wrongfully convicted and sitting on death row in San Quentin State Prison for the past 15 years. On April 14, 2003, Stephen Brooker was shot and killed at his home. The defendant, Eric Anderson, is accused of trying to rob Mr. Brooker and being the shooter, along with two others who were found guilty of being involved. One is named Apollo Hunt, the other Brandon Hanshoe. Before the victim died, he gave a description of the shooter: black and white cap, salt and pepper hair, with a full beard, between the ages of 35 and 45 years old. No mention of any glasses. This description does not fit Mr. Anderson, who was only 29 years old at the time. Also, please see photo on the front of his website that was taken 3 days before he was arrested. Anderson was arrested of this crime after Valerie Peretti contacted Crime Stoppers to try and collect the reward. Valerie Peretti was at the time the girlfriend of Apollo Hunt, and the two of them discussed what to tell the police to try to get the reward money. In Valerie Peretti's first couple of stories, she left out her boyfriend's involvement. When she had went for a polygraph exam, she had changed her story in the middle of it and still failed the polygraph. In total, she changed her story 7 times before trial, yet none of her stories held up to all the knowledgeable facts in this case. Yet Valerie Peretti was paid $10,000 by the prosecutor through Crime Stoppers even before the preliminary hearings or her statements were investigated to be factual. The rush to judgment led to the need for the prosecutor to double down on his lies after $9,000 of the reward money came from the victim's family. He couldn't just say, "Oops, my mistake. I gave $9,000 of your money to a liar," and hampered any case going forward on the others. At trial, there were multiple theories of the case against Mr. Anderson that was heard by the jury. Due to the judge refused to sever codependents and Anderson's codependents, lawyers acted as second and third prosecutors against Anderson. One in particular is the prosecution's theory was that Anderson was the ringleader, while Hunt's lawyer, with the help of another version of Valerie Peretti's story, was that Anderson more or less forced them to go along with him to rob Mr. Brooker, and they did so because they were scared of Anderson. However, neither of these theories were valid. Key reasons being that, according to Peretti, Hanshoe had a gun as well. And as far as Anderson being a ringleader, Anderson's cell phone records show the first time he had called Hanshoe was April the 6th, only 9 days before the murder. Beyond that, records and testimony show there was a group of people planning to rob Mr. Brooker as early as the summer of 2002, which Peretti testified at trial to. Those people mentioned in these numerous meetings were Randy Lee, Zach Paulson, Brandon Hanshoe, and Apollo Hunt. Randy Lee knew about a safe at the Brooker's house because he had gone to school with the victim's son, Eric Brooker. Randy Lee was the only one who factually knew where the Brookers lived. Meanwhile, there was no evidence or even statements of Anderson and Lee meeting and discussing anything about the Brookers. But there was testimony about is that Randy Lee had enticed in multiple meetings to discuss Mr. Brooker's fate from as early on as the summer of 2002 to only a short time before the murder happened. The people he met were Zach Paulson, Brandon Hanshoe, and Apollo Hunt. That Lee was willing to show them where the safe was and help plan, but didn't want to go in person. For this, he wanted 15% of the money, according to court testimony. Zach Paulson was more than just a friend of Hoon and Hanshoe. He had stated in police records that he and his friends were all part of a gang called the Peckerwoods. However, this gang evidence was not allowed at trial, which would have undermined the prosecution's theory of the case that Anderson was the ringleader, when facts show Anderson was the only outsider in this case, and that the co-defendants and the majority of the prosecution's witnesses at trial were either a member in this gang or associated with them as friends and grew up with. Another key person that comes up in this case is Eric Swanson, a third Eric. He is referred to as Eric the drug dealer from testimony by both Brady and Hanshoe. In fact, this Eric fits the description much closer of the shooter that Mr. Brooker gave before he died, due to testimony about his age, graying hair, and being unshaven. This Eric was far better known to Hanshoe and his friends. He came over to Hanshoe's place almost daily and knew him for much longer than Anderson. Yet the detectives in this case intentionally changed witness reports and misled other witnesses' testimony and statements about there were even being a second Eric. And detectives purposely never had shown anyone they interviewed a photo of Anderson and Eric Swanson to clearly determine which Eric they could be referring to. A prime example of this fact, as seen in Patricia Colgan's testimony, that the first time she had seen Eric Anderson was in fact in court. She didn't know there was two Erics, and she was talking about the other Eric. Karen Barnes was the neighbor of Hanshoe and had learned of Anderson from the media, had made statements against Anderson, but at trial, she also admitted the person she was referring to was 6 feet tall and had collar-length hair that came over often. These facts are proven and seen on the transcripts regarding prosecutor and detective. The prosecution's case was weak. There was no physical evidence such as DNA, fingerprints, fiber, etc. that links Anderson to the murder case, nor is there any corroborating evidence. However, there is evidence of Anderson's cell phone records that Valerie Brady had lied about meeting Anderson over at Hanshoe's place the day before the murder. Phone records show Anderson was never near Hanshoe's place on April 13th and was in fact in a different city. Yet even knowing evidence in the prosecution's possession that this key witness was lying, the prosecutor doubled down on her lies by giving Hanshu a plea deal in the middle of jury selection. Not only did this violate the 30-day notice rule, but more importantly, the prosecutor had months before they held a free talk with Hanshu and his lawyer. Free talk is when someone like Hanshu is free to tell the prosecutor what he knows and is willing to testify to for a plea deal, without the prosecutor being able to use his statements against him if there isn't a plea deal. From this free talk statement, again, the prosecutor knew and the evidence beforehand that Hanshu was also lying. In Hanshu's free talk statement, Hanshu accuses Anderson of 2 other crimes besides the murder. One was a burglary where he claimed the murder weapon was stolen a short time before the murder. The second one was where he accuses Anderson of ramming the door and setting off the alarm to a house next to where Brooker lived. Hanshu had also claimed this happened on April 13th and that he was also at this place. But Anderson's cell phone records prove that both Brady and Hanshu committed perjury, since cell phone site locations show he was never in that area for the whole day of April 13th, and in fact in a different city. Moreover, the alarm company for the house next to Brooker's home came into court and testified that the alarm was never set off April 13th or any time that month, as Hanshu testified to. Furthermore, regarding the first accused burglary, police records showed there was no evidence of this, and there was not a similar burglary reported where a .45 handgun was stolen. What is even worse than a lying witness is when the prosecutor had this evidence and knew both his witnesses were lying, he gave Hanshu a plea deal, even knowing his testimony would be perjurous ahead of time. Then, to create confusion about if Hanshu lied or not, when the detective got on the stand, the detective lied about the evidence that doesn't even exist to bolster and support Hanshu's story regarding the first accused burglary. By testifying, there was a similar burglary reported to what Hanshu claimed. However, later on at the end of the trial, a stipulation was read to correct the detective's testimony without flatly saying the detective's lie. Moreover, to this day, both police records of when Hanshu was taken around to point out these places are being withheld. Brady violation, withholding exculpatory evidence. Just before closing arguments, the judge threw out the charge of conspiracy against Randy Lee, which was the only crime he could have been convicted of, and put the full onus on the jury to find Anderson guilty of being the ringleader, since the judge took away the option of the jury to find Lee guilty. Last of all, in closing arguments, the prosecutor lied to the jury about Hanshu's plea deal, saying he was free to say that Martians came down and did it, he would still get his plea deal. Therefore, he had no reason to lie, yet the facts are seen in transcripts and other documents provided that Hanshu's plea deal locked him into testifying to his perjurous statements made during free talk, and that if he altered or lied, he could be charged with perjury and lose his deal. Hanshu received 17 years through his plea deal. Randy Lee was set free. Apollo Hoon was guilty, and Anderson was found guilty and sentenced to death. What you will read in the issues section of the website are the details of the stuff in this summary. The issues are divided into sections based on individuals like Hanshu and Brady in order to highlight their testimony as being more than just not believable, but lay out their perjurous testimony. Likewise, in the first section, labeled Prosecutor and Detective, I point out how corrupt the acts were and how they were responsible for doing them. As you will see, each time a fact is mentioned, there is a page number that follows. Most are from transcripts that are labeled RT, then the page number, where the fact or quote is found. This is so everything you read on the website is backed up with facts and irrefutable. These documents are easily found on the website for you to see for yourself. The related documents follow each section. You don't need to read all the documents to understand the issues in this case, but there is proof of everything I've said. Near the end, you will find a section that is of Anderson's trial lawyer's closing arguments in full. You may want to read this first so that you can see how she outlines the case. And it also shows that the trial lawyer makes many of the same arguments about the case as I do. Anderson's trial lawyer points out there is no physical evidence nor any corroborating evidence, and that the state witnesses were lying. The only point she fails to do is to attack the outrageous government conduct done by the state in order to obtain a wrongful conviction, aka a conviction by any means necessary. Last of all, the website is long, but it's needed to be thorough. Most of it, however, are documents that are downloaded onto the website for the sole purpose to prove everything on the website is factually true and leave no doubt with the evidence provided. After you read the facts of Anderson's case for yourself, I ask you to join the petition to overturn this case at https://www.change.org/justice for Eric Anderson. Thank you very much for your time.